Mr. Gayfield and Mr. Rennie, could you mute your video and audio so we just have the attorneys for the first case? Great. I'll ask the court be open. Thank you.
I see only one attorney.
Do you see Mr. Gross or Mr. Ross?
Yeah. I don't know their names, but I now see two. That's fine.
Okay, great. Thank you.
The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, thank you. I think we're all on. Judge Richardson and I are on video, and Judge Motz is on with us by audio. But all three of us are on, and we'll begin by hearing case of Vandross versus Sterling. And Mr. Gross, is that the correct pronunciation?
Yes, sir, Gross? It is.
Okay, why don't you begin?
Thank you, Your Honor, and may it please the court. The state of South Carolina tried Charles Vandross for murder 3 times before a jury convicted him. The prosecution relied heavily on forensic evidence and expert witness testimony. Mr. Vandross never had the benefit of a crime scene expert because his trial counsel operated under the mistaken belief that state funding was not available for expert witnesses because Mr. Vandross's family had retained him. The South Carolina State Court and subsequently the District Court unreasonably decided this issue. The state court order of dismissal found that trial counsel was effective in his representation of Mr. Vandross under prong 1 of Strickland. This state court finding that trial counsel was effective under prong 1 of Strickland was contrary to well-established, firmly established federal law decided by the Supreme Court going back to Ake versus Oklahoma. The District Court report and recommendation repeated this same error, except the District Court did not even consider the prong 1 finding the District Court. They deleted that from its order altogether. The report and recommendation and the opinion on the report never addressed the specific impact of what trial counsel's error was. Also did not consider how this matter was presented to the South Carolina Supreme Court. And in order to understand that, it's necessary to understand sort of the unique procedural history of this case. When Mr. Vandross was in post-conviction, his court-appointed PCR lawyer ultimately had a conflict of interest with Mr. Vandross. Mr. Vandross raised that in a hearing before Judge Russo and specifically talked about how matters that should have been said during the PCR hearing were not raised at all. Judge Russo had a very lengthy colloquy with Mr. Vandross where they discussed whether Mr. Vandross should get new counsel at that point in time or whether or not they should wait for the PCR judge, Judge Newman, to issue an order in the case. Mr. Vandross, of course, wanted to have counsel changed at that point and have an opportunity to cure the matter. Judge Russo opted for the second option, which was to see if Judge Newman granted relief. If Judge Newman granted relief, then this issue was moot because Mr. Vandross would get a new trial. If Judge Newman did not grant relief, then Mr. Vandross was going to be entitled to his hearing on the conflict of interest and the determination as to whether or not he would get new counsel and be able to reopen the evidentiary hearing. Judge Newman, of course, issued an order denying relief. That order was likely drafted by the Attorney General's office. And the hearing that Judge Russo promised never took place. There's probably several reasons why it never took place. The first reason is that appointed PCR counsel during the hearing in front of Judge Russo basically said he wasn't going to do anything else for Mr. Vandross after that hearing, and he didn't. He didn't even file the Rule 59E motion that's necessary in our state procedures before you go up on appeal. Nobody, it appears, ever called to Judge Newman's attention that Mr. Vandross had been promised this hearing. So both PCR counsel and the Attorney General dropped the ball on that issue. And that's when Ms. Franklin Best and I got involved in the case. And we immediately realized the procedural deficiency that was the result of the hearing in front of Judge Russo. We immediately recognized that the conflict of interest was a major issue in this case. We immediately realized that Mr. Vandross was entitled to this hearing based on the ruling of the court, and he didn't get it. So the first thing that we did in the South Carolina Supreme Court is that we asked the Supreme Court to remand the case to the circuit court so that Mr. Vandross could have that hearing, or an alternative to just bypass the remand and recognize that the conflict of interest was substantial and required the appointment of counsel that would be able to have a new evidentiary hearing. So it's important to understand that the relief that we were asking for in our state's highest court was to reopen the PCR where Mr. Vandross would have an opportunity with conflict-free counsel to present the evidence on the prong 2 of Strickland, which of course is prejudice. It wasn't until we got to the district court where the magistrate court judge granted the motion for funding so that Mr. Vandross would be able to hire an expert witness. And of course, you have the curriculum vitae and the affidavit of Roger Morrison, who is a well-respected crime scene expert, retired from the state of Alabama, consulting in private practice, and has been cited with approval by this court in prior opinions. And Mr. Morrison's affidavit, we believe, establishes prejudice. And you have to go back and look at the trial history of this case and realize, as I opened, that the state of South Carolina tried Charles Vandross 3 times before they were able to get a jury to convict him. The first 2 juries.
Mr. Gross, you indicated that the affidavit of the expert established prejudice, and if I read the affidavit correctly, he listed a number of tests or investigations that should have been conducted, but there is no forecast about any one of those to suggest that it would have been fruitful. How do we handle that?
Well, in addition, I think there's 2 ways that you can handle that, because in addition to suggesting other things that could have been done, he also suggested things that could have been done in cross-examination. Well,
I understand, but I'm trying to get to the prejudice prong. Right. And anybody can sit around and say, you could have done this, 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 this. The question is, had it been done, would it have led to something fruitful? In other words, there was really no opinion that I thought. I didn't see any opinion as to anything that would have changed.
Well, again, if you look at the Supreme Court decision in Kyles versus Whitley, they say that a conservative approach that a criminal defense lawyer can take is to challenge the reliability and the integrity of the investigation. And that could have been done with Mr. Morrison testifying. And this is a case where the jurors were already having a hard time believing the direct evidence testimony from Joanne Super Wilson. The second way you could look at it, Your Honor, and it's probably more of a Martinez path, is, you know, the prong one of Strickland, the state Supreme Court is just objectively wrong. You could then look at the deficient process, the deficiency of PCR counsel, and you could remand this case to the district court where we could have a hearing. I believe we did ask for a hearing. Mr. Morrison could testify. There could be more discovery and an opportunity to develop the prejudice prong in more detail. We think that on the record that we have right now, this court could grant relief and remand to the state courts of South Carolina for jurors to make the determinations on this issue. But if you disagree with us, I think the second alternative is to remand it to the district court for a hearing on the prejudice prong.
Mr. Gross, can I ask, I think Judge Niemeyer's question in a slightly different way. You're obviously an experienced trial lawyer yourself. If you were standing in front of the jury for Mr. Vandross, and you had Mr. Morrison's affidavit with you, tell me the two best things in the affidavit that you would use in front of a jury, right? That you would actually like say. I mean, I'm just trying to figure out, you know, if you got that information, let's assume that information exactly what the affidavit says. Tell me the two things that you would use from that in front of the jury.
All right. And Judge Richardson, I appreciate the question, but I think that if I was standing in front of a jury, I wouldn't just be standing there with Mr. Morrison's affidavit. I would be standing there being able to reference his testimony. And there's...
I understand that that's not the only thing you're going to reference, but I'm saying... Right. In addition to all the other arguments that you would, you know, marshal in his favor, I want to know what's different about the Morrison affidavit. What does the Morrison affidavit add? Okay. Right? Do you understand what I'm trying to say? I want to see what are you going to cite, or what are you going to say about Morrison affidavit?
For example, you know, in 3D on page 1 of his affidavit, you know, Mr. Morrison has some expertise in DNA, and this goes to the failure of law enforcement to look for Mr. Vandross's DNA or fingerprints on the roll of duct tape. And this would directly undermine her credibility, which was necessary for the jury to get to a conviction.
But during the trial, let me just stop you on that one. So your first example, that the fact that the government didn't test for DNA was raised at trial by defense counsel, wasn't it?
Well, it was, but it wasn't raised with the benefit of an expert testimony, a defense expert, which the case law recognizes that jurors are much more likely to be convinced by defense experts than just questioning of a lawyer.
Okay, so what's the second, if that's the best thing, give me the second best thing that you would rely on from the Morrison affidavit in the closing argument in front of a jury?
And I don't know that I'm necessarily going in the order of best, but I was just going in the order.
I'm just asking for the two best. So maybe that's the second best argument. What's then the best argument?
Well, you know, if you look at on page 2 of the affidavit, M and N regarding, you know, the testing, and obviously we would like to have had access to the gun where Mr. Morrison could do some testing to determine how loud the gun was, to assess Ms. Wilson's credibility. And then we're related to the gun. You have issues about, in paragraph N, about the GSR. And so I think that that would be very persuasive to the jury. And that,
well, just following up on Judge Richardson's question, you've told the jury nothing. You just said it would be helpful if we tested it, but the jury doesn't hear. They say, so what? In other words, how does that change the evidence on which the jury makes a decision?
well, I think that you have an expert who can be able to explain to the jury how that makes a difference. And you've got to realize that in the posture that we've come here is every court before us has found that trial counsel was effective under prong one. I mean, we've never, Mr. Vandross, I mean, the breakdown in the process where this case has gone off the rails is Mr. Vandross has never had the opportunity through an expert to develop these matters in a hearing where prejudice is considered. And that's why, you know, I think that there's this Martinez vehicle under prong two, where you can remand it to a magistrate to have the testimony and consider the testimony, determine whether or not there needs to be additional discovery, and decide the issue.
Counsel, this is Diana Mott. Just so I understand what you're saying, you don't think there was any obligation for you to put in an expert who would opine that this made a difference? Not that it could make a difference and it would be a good idea and there was a possibility, but that it did make a difference. Is that what you're saying?
And I see my time is up. Can I go ahead and answer?
You can answer the question.
Yeah. Well, I think that, you know, the affidavit that we has raises some serious issues about what an expert could have done. And we did have a request to be able to have an evidentiary hearing where this could be developed in more detail, and we were denied on that. And so that's why I suggest that second vehicle as a path of relief.
So the direct answer to my question is yes, that is what you're maintaining, right?
Well, I think, yes, we have an obligation to present an expert and to develop what those expert opinions are. And in this case, we needed a hearing to do it.
Right, your expert had not done that yet.
Well, and our expert had done this based on a review of the trial evidence with the...
But he had not issued an opinion saying these things would make a difference, did he? I thought he was just saying they were a good idea.
Well, I think these are things that he's saying that could have been raised in his testimony.
Could make a difference.
I think it
could make a difference.
I think it would make a difference. I think it absolutely would have changed the result of the
I'm
trial.
asking you what the expert said. Did the expert say it did make a difference or it could make a difference?
I think that when you look at this affidavit, there's enough in there to conclude as a matter of law that it would have changed the outcome of Mr. Vandross's trial.
Well, how can you say that when we have no opinion that changes any of the forensic evidence? In other words, there's no test that has been said that's wrong. There's no prediction as to what a test would produce. In other words, basically, it's just an idea list.
Again, you know, I think it comes back to the value of having an expert come into court and say, you know, based on my training, education, and experience, this is how you conduct a crime scene investigation. This is the things that you do. They did not do this. This evidence would be directly related to whether Ms. Wilson was credible or not credible, and that changes the outcome. This jury already was not inclined to believe her. Certainly the first two trials hung on her credibility. An expert would have tipped the balance in favor of acquittal in this case.
All right, you've got some rebuttal. We'll hear back from you. Let's hear from Mr. Ross at this point.
May it please the court. This issue has already been adjudicated on the merits in state court. And as such, not only is the decision entitled to deference under 2254D, but also the Martinez exception simply doesn't apply. We're not dealing with a situation where Mr. Vandross procedurally defaulted a claim for failing to raise it in state court. To the contrary, this man had a full evidentiary hearing. The hearing lasted several hours. He was appointed counsel. And after that hearing, he moved to amend his pleadings to capture this particular issue. He raised the issue at the hearing, and he captured the issue in his amended pleadings. The PCR court subsequently ruled on the merits. The court held that counsel was effective and that there was no prejudice. At no point in time did the state of South Carolina deny Mr. Vandross any opportunity to present evidence, deny him access to court-authorized funding, or prohibit him from presenting his case in court. Mr. Vandross now challenges the state court decision for not giving him a second bite at the apple. A year and a half after the PCR court made its ruling in this case, he sought that second bite. And it was not unreasonable for the Supreme Court of South Carolina to deny him that opportunity. This is not a situation that this court faced in the Winston case. This is not a situation where the state court unreasonably truncated Mr. Vandross's ability to develop the facts. As you'll recall, in Winston, the petitioner in that case was denied the opportunity to conduct discovery. He wanted to issue subpoenas in the case, and the Virginia State Court denied him that opportunity. And this court held that its ensuing decision was not entitled to deference. That situation didn't occur here. Again, you got a court-appointed attorney. That attorney raised this issue as well as numerous other issues before the PCR court. This wasn't the only issue that Mr. Vandross was trying to obtain relief on. Indeed, there were a whole host of issues addressed in the PCR court's order. This is also not a situation where the new evidence that Mr. Vandross has provided has fundamentally altered the substance of this claim. Again, in Winston,
Mr. Ross, I'm curious, you addressed that issue. Do you understand Mr. Vandross to make that argument? I sort of was looking for that argument, but I never saw Mr. Vandross allege anywhere that the new information here fundamentally altered the claim that was presented in the state PCR court. Do you understand them to make that argument? That's a separate argument that we can address. And I was looking for it. But when I go back and look at the briefing here, I don't see that argument. Am I missing that argument? I understand this is not in your interest, but you're an officer of the court. Do you understand them to be making that argument?
He hasn't made the argument, Your Honor. What he has made is the argument that Martinez applies. And that's one avenue that potentially this court could grant relief under Martinez. So that's why I felt it was necessary to raise it.
I'm happy for you to address it. I just was curious about whether it was an argument that was actually raised.
It was not contained in his brief, but it's an issue that if you're going to seek relief under Martinez, that's potentially one avenue the court could do. But that avenue is closed under this court's reasoning in the Winston case, in the Wise case, and also most recently in Moore versus Sterling from earlier this year. The test under Winston in whether or not new evidence fundamentally alters a claim is not whether that new evidence makes the claim stronger. The test is whether or not there is any evidence in the state court record that Mr. Vandross could use to prove an essential element of his claim. And if you look at his brief, he's relied exclusively upon evidence raised in the state court proceeding for the first prong under Strickland, the deficiency of counsel. He's relied upon trial counsel's testimony at the PCR hearing regarding whether or not the expert would be beneficial, whether Mr. Vandross had the opportunity or ability to pay. So everything he's hanging his hat on to establish the first prong was raised before the state court. Therefore, if you apply that test in Winston, this is not a different claim. The heart of this claim remains the same, that trial counsel failed to retain an expert either for affirmative testimony or simply for consultation. And that's what the PCR court ruled upon. So this new evidence doesn't change things. Because there is an adjudication on the merits, Martinez simply doesn't apply. By its terms, Martinez applies to situations of procedural default of a claim. And the Supreme Court defined that term in its opinion. Procedural default meaning a state court not adjudicating the claim on the merits because the petitioner did not abide by a procedural rule. And if there were any doubt about the reach of the Martinez exception, this court removed all doubt earlier this year in the Moore versus Sterling case. This court explicitly held that Martinez is not an avenue to present additional evidence where the state court ruled on the merits, where the claim was not procedurally defaulted for failing to raise it in state court. So the effectiveness or ineffectiveness of PCR counsel simply doesn't matter.
Can I ask, with apologies to Judge Motz for stealing her question, but sort of ask you the question that she asked your colleague, and that is it ever sufficient for a petitioner in a habeas case like this one to put on expert testimony that there's evidence that have made a difference, as opposed to, this is the evidence that a lawyer argues would make a difference? So in other words, the possibility that there's a test that might turn up pertinent evidence, could that ever suffice to show prejudice?
Well, it hadn't changed the nature of the evidence presented before the jury. So again, if an expert essentially reads a transcript and identifies perceived holes in the state's case, he still hasn't affirmatively changed the nature of the evidence. So the jury is going to hear the same evidence at trial and based on what was presented before the PCR court. So the answer to your question is no. Unless the expert offers some type of affirmative evidence, some type of new test, or challenging the results of the state's experts, it's speculative to assume that prejudice would exist in that case, Your Honor.
Excuse me. Hi, this is Diana Motz. I'm not sure I really understand your response. It seemed to be that you thought that you could make a proffer with an expert, and that if the proffer came true, if the expert said what the proffer said, then it was up to the jury to decide whether that would change the case. What I really was getting at in my question, maybe Judge Richardson was too, is does the expert have to opine that in his expert view, this would change, this new whatever it is would change things, or not?
Your Honor, I think the key would be there has to be some type of change in the nature of the evidence. That could either be through the expert's testimony that the evidence the state presented was unreliable, or it could be through new evidence new testing that the expert had conducted. But there has to be some type of change in the nature of the evidence after that expert's opinion.
But why?
I think I understand the change. What I'm asking you is it necessary that the expert, that this change would make a difference in the experts that will agree that there is something that the expert has said is new, right? That's what you were getting at. Either a new test or something that he points to that should have been done otherwise or something. Does the expert also have to opine that that would have made a difference? Or is that not necessary?
Ultimately, that's a decision for the court. It would certainly help the petitioner's case, but I don't think it's necessary. That's one thing the court could take into consideration in assessing prejudice, but determining whether or not there would be a fair probability that the result at trial would have changed, that's a decision for the court to make.
I'm just trying to follow that through, because it'd be a little odd for us. I mean, Mr. Morrison here may be great at looking at crime scenes, but why would we think he's an expert on what juries do?
Your Honor, you hit the nail on the head. That would ultimately, it's for the court to decide. And the strength of that opinion would be one of the factors the court would use. I don't think Mr. Morrison's opinion, as Your Honor mentioned, he may have great experience on crime scene investigations, but he's certainly not an expert in sound suppression. He's certainly not an expert in a host of any other realms.
And he might be an expert in, being a jury consultant. We just don't know that about him.
Yes, Your Honor, that's correct.
I suppose that if the expert looked at the tests that were actually conducted and gave the opinion that the state's expert made a wrong reading of it, didn't apply scientific standards, and that when you do apply the scientific standards, the outcome is different, that would be new evidence, wouldn't it?
Yes, Your Honor, it would. But again, that was not done here. So we have an adjudication on the merits. Martinez, by its terms, does not apply. The issue presented before this court, then, is whether or not the state court's adjudication of this claim is reasonable under 2254D. And again, there are two prongs, as the court is aware, of Strickland: deficient performance and prejudice. We talked about prejudice at length, but the state court could have also denied this claim on deficient performance as well. Not every case requires an expert for it to be tried effectively. Strickland recognizes that there is a wide latitude of strategy for counsel to pursue. Very rarely, as the court recognized in Hinton, as the court recognized in the Richter case, very rarely are you going to have a situation where the only reasonable strategy is to retain an expert. The extent and the limitation.
I think if I understand the petitioner's argument, however, is that the reason given by defendant's counsel for not getting an expert was the funding, which was an erroneous assumption, and that was the deficiency in it, with the assumption that had there been funding, he would have gotten help, forensic help. It seems to me to focus on the deficient performance is a much more difficult task than to focus on the prejudice.
It's a more difficult task, but the issue here is not whether the PCR court was correct in its ruling. The issue is whether or not it was unreasonable in its ruling. And in Mr. Vandross's argument, he's assumed a host of facts that simply weren't presented before the PCR court. He has assumed that trial counsel believed experts were necessary in this case. PCR counsel never, or trial counsel never testified to that at the PCR hearing. He testified that an expert may be beneficial. A lot of things can be beneficial. Strickland does not codify things that are beneficial. Strickland does not set a floor of the best practices. Floor under Strickland is professional incompetence under prevailing norms. Different defense attorneys can try cases different ways. No two defense attorneys, even the best ones, aren't going to try a case the same way. So in this particular case, trial counsel said it may be beneficial to have the sound expert. He never testified that it was necessary. So the PCR court could have held reasonably that this was a situation where trial counsel could have effectively represented his client through cross-examination alone. And that's what trial counsel did in this case. These perceived holes in the state's forensic evidence, he raised all of them to the jury. To the jury, he had the CSI forensic technician concede that there was no physical evidence putting his client in the home. He had the gunshot residue expert concede that there was the potential that the lead particles found on his client were incidentally transferred. He had the DNA expert concede that his client's DNA was not found on the duct tape. So all these holes, alleged holes in the state's evidence, trial counsel raised before the jury. Getting to prejudice, again, this is a situation where Mr. Morrison's affidavit to this day, he has not identified how the result at trial would have changed. He's not articulated any change in the nature of the evidence that would have been presented to the jury. He simply read the transcript and identified potential holes in the state's case. There's been no affirmative testing on any piece of evidence. He's not challenged any expert's qualifications. He's not challenged any expert's opinion. He's simply identified perceived limitations in the state's case in the same way an appellate attorney would identify limitations in the state's case. Federal habeas is designed to ensure and correct extreme malfunctions in the state criminal justice system. This is not that case. And if there are no further questions from the court, I'll cede the rest of my time to the court.
All right, thank you, Mr. Ross. Mr. Gross?
Thank you, Your Honor. May it please the court. Picking up where Mr. Ross left off with the testimony of trial counsel, the question at the PCR hearing was, did you hire or retain any experts in this case? The answer was, I did not. Told him that I thought it would be very beneficial to us, but I was retained and he did not have funds to do that. And then he continued to explain why Mr. Vandross couldn't hire an expert because he couldn't even finish paying trial counsel. And based on that testimony, at page 1167 and 1168 of the joint appendix, the PCR court found counsel testified he wanted to retain experts in this case, but applicant had no funds with which to hire these experts. And then on 1168, there's a finding under prong 1 of Strickland that counsel was effective. And that is just objectively wrong. As the court pointed out a minute ago, trial counsel just failed to understand 8 versus Oklahoma, failed to understand that South Carolina has a statute and a procedure directly on point where he's able to get the experts.
Mr. Gross?
Yes, sir.
Is that, do we analyze that only subjectively. So imagine that he says, listen, the only reason I didn't do this is because I didn't think I had money. And that was his subjective belief. And let's say I agreed with you that that's ineffective because he was wrong. Thought that we looked at it objectively, though, whether the strategy employed was a reasonable one. So in other words, using cross-examination instead of an expert, whether the question is that objectively unreasonable, not whether this lawyer subjectively screwed up. Is that?
And I think this lawyer objectively screwed up. I mean, when you look at his testimony, he said an expert would be very,
isn't that a question? But that's his subjective view. Don't we have to, assuming we got to this question, right? But don't we have to ask the question of whether a reasonable, objective defense lawyer could decide to not hire an expert and instead use cross-examination to flesh these issues out? I mean, it seems like to me that's the question to which the state court gets deference on, is the objective question, even if we agree with you that subjectively, this lawyer screwed up.
Well, the lawyer objectively screwed up because he didn't understand the law. The lawyer also testified and that an expert would be very beneficial in this case. This is a case where the state relied on the one witness's testimony who was very uncredible, that led to 2 hung juries, and this whole host of forensic evidence, which is directly what we tried to bring in this hearing. And so, I think you have to look on prong one. I think you have to look at the order, and the uncontested testimony from trial counsel was this case called for an expert. We didn't get it because I didn't understand how to get it. And so I think, prong one, the state Supreme Court, the state courts, the district court just got it wrong. I mean, it's contrary to, well-established law. Prong two, this is not the case. The Attorney General referenced the recent Moore opinion. And I know Your Honor was involved in that case. The Moore case is very distinguishable because that's a case where some mitigation was presented in a capital case, and arguably better mitigation was presented in the federal case, but the evidence was still the same claim. Here, there was no expert at any level in the state court. It's not that we're trying to say that on prong two, we're not trying to say that we've presented something that's different or better. We've presented something new, which is what we asked to do in the state court.
Can I ask a question? And if you don't know the answer to this, that's fine. I can read it myself. But I asked your colleague, do you argue anywhere this idea that this new evidence so fundamentally changes this claim that it was not an adjudication on the merits in the state court?
Well, we certainly argue Martinez, and we argue that we point out that no evidence was presented on the prejudice prong in state court. So whether you call it fundamentally altered or just entirely new evidence presented on prong two, this is a different claim than what was argued in state court on the prejudice prong. And perhaps there's a hybrid way to get to it. It's exhausted on prong one, it's not on prong two, and this is a new claim.
All right. Thank you, Mr. Ross. Excuse me, Mr. Gross. I think your time is up, right?
It is.
And we appreciate having your argument. I notice you are pro bono, and of course, that's a great service to the court and to your client. We'll normally come down at this point in time and greet counsel. That's the tradition in the Fourth Circuit. It is a wonderful practice that was begun by Judge Parker down in the 1930s, and we've always followed it. But in these circumstances, any greeting has to be virtual. And so we welcome you to the court and thank you for your arguments. And we'll stand adjourned till the next case. Thank you.
Thank you.
Thank you, Your Honor.
Mr. Rennie and Mr. Gayfield, if you can unmute your video, and Mr. Gayfield, if you can unmute your audio. Great. Judges, can you see both counsel?
Yes, we can.
Okay, I'll ask the courtroom deputy to open court. Thank you.
Thank you.
The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit.
All right, we'll proceed on the next case, which is Mann versus United States. And Mr. Gayfield, we'll hear from you first.
Thank you, Your Honor. Good morning, and may it please the court. In 2011, the Manns generously agreed to donate a house on their recently purchased property to Second Chance, a 501c3 tax-exempt nonprofit. There are many nonprofits that accept donations of deconstructed building materials. But after researching their options, the Manns became excited about Second Chance's unique workforce development mission, which provides comprehensive training and education to disenfranchised Baltimore citizens who face major barriers to employment. The Manns had their house appraised, and they proceeded to execute and deliver a contract to Second Chance, conveying all right, title, and interest in the improvements to the charity. Under Maryland law, the man's contract constructively severed the house from the underlying land, converting it to personally that was owned by Second Chance, while the man's retained ownership rights in the underlying real property. The man's did not retain any interest in the house, nor did they impose any restrictions, contractual or otherwise, on Second Chance's ownership rights.
Well, how do we understand the contract that the man's entered into with the contractor, which was to get the permit, demolish the old house, and build the new house, and that Second Chance understood that it would go only so far and then turn the project over to the contractor to demolish the house?
Well, I'd have two responses to that, Your Honor. Number one, whatever the man's other intentions were or their other contractual relationships with a contractor, at the end of the day, that wasn't an interference in Second Chance's property rights. Second, when Second Chance deconstructs a house, it doesn't perform the demolition process anyway. So anyone who wants to rebuild a house or build a house on a previously deconstructed lot still needs a contractor to demolish the frame, the foundation.
Let's stick back with just what you said. Can I just interject there a question? You said First Chance does not engage in the demolition of the house.
Correct.
What's that mean?
What that means is the deconstruction process is Second Chance coming on site with their workforce development team. And these are, ex-cons who are I
understand all that. I want to understand what demolition. They do not perform the demolition of the house. What are they saying?
Correct. So what happens is Second Chance takes away everything of value that it's able to extract after it employs its workforce program. It takes out the appliances, takes out the copper pipes, HVAC system, the fixtures, sometimes personal properties in there, and that was the case here too. They take that out. They take out the cabinets, windows, doors, but you do have components that are left after deconstruction typically.
Such as what?
You have the roof, you have frame, you have drywall. You can't reuse drywall, right? So
the chimneys, they had two chimneys or whatever it was too, right?
Chimneys are probably typically kept, although Second Chance certainly takes away brick materials, patio materials. The point is Second Chance has the option when it deconstructs a house to take away as much or as little as it wants. But
I understand that. You go to that side, but I'm interested in knowing when they say they don't perform the demolition, that's consistent with the fact that the contractor performed the demolition in this case.
Correct. And there was an issue, or at least it was initially a government contention that the man's had gotten the benefit of a demolition contractor by way of Second Chance. And it turns out, and the testimony is clear on this, and this was a stipulated fact, demolition didn't happen by Second Chance. That's not what they do. They're not a demo company. They don't bring in a wrecking ball. They don't bring in big equipment to knock stuff down. That's not to say
that's a setup for my real question is if Second Chance doesn't perform the demolition, but the frame and the roof is left for demolition by the man's and their contractor, then it's hard to conclude that the man's conveyed all of their interest in the house as personality to First Chance. Second Chance.
Thank you, Your Honor. I have two responses to that. The first is we're really looking now beyond the contract to what actually happened. The point is Second Chance could have taken the house away on a flatbed if they wanted to. And look, if we were in that situation, then maybe the man's would have had to reduce the value of their donation by the demo, the equivalent of a demo service that you got. Nothing prevented Second Chance, once that contract was signed, from hauling the house away. They've done that before in other situations. They chose not to do it here.
But don't we have to look at the actual transaction? In other words, what somebody writes on a piece of paper and says, I'm doing everything necessary to create a tax deduction, but then in fact that's really nothing more than a generalized statement, and the actual transaction, the real transaction, involves retention of an interest in the house for demolition purposes.
Well, I have two responses to that too, Your Honor. Number one, under Section 170, the law is clear that you have to look to substantive state law. Maryland employs the objective test when it comes to interpreting a contract, and that contract that satisfied the statute of frauds here unquestionably should have been the beginning and end of the analysis. But even if you start looking beyond the contract to the record,
IRS never does that. The IRS always looks at the substance of transactions. They're able to call transactions shams based on looking at the substance of the transaction. Here, the deduction is allowed if the man's conveyed all their interest, not reserving some, all their interest in property. That's a requirement of Section 170, isn't it?
Yes, Your Honor. It is a requirement of Section 170 to donate your entire interest. And that is what the Manns did. The record's clear. Mr. Mann testified to that effect, that he had conveyed all interest to Second Chance. They could have done whatever they wanted, and they weren't restricted from doing whatever they wanted. Second Chance testified to that effect.
Counsel, let me ask a slightly different, it's obviously a hypothetical question. If I called the Salvation Army up and said, I've got 100 shirts that I want to donate, and each one of them I think is worth $1, but I want you to come pick them up. And so I'm going to give you sort of an easement onto my property for 10 days. Come pick up the shirts, and whatever's left, I'm going to throw away. And so Salvation Army shows up, they look at the 100 shirts, and they take 5 of them because those are the only ones that they want for whatever reason. So they take those 5 and they leave. Can I take the $100 deduction because I gave all of those shirts to the Salvation Army, even though at the end of the day, the Salvation Army only took 5, and I was left with the burden to destroy or dispose of the 95 that they left behind? Do I get a $100 deduction there? First, answer that. And then second, once you answer the hypothetical, explain to me why you think your case is like or different from that.
Well, I think this case is different because you have to remember.
Answer the question, answer the hypothetical first, and then come back to why you're different.
Well, I think it also depends on whether you had a contract with Salvation Army in which you had already granted them the interest in the 100 shirts.
I got an oral contract. I don't care if it's in writing. All right, so I got a written contract with Salvation Army.
So I think
in that case, do I get the $100 deduction in your view?
No, because what Salvation Army has done is they have returned 95 of the shirts to you, and those shirts still unquestionably have value. Second Chance doesn't return anything of value. They take control of the structure. They employ the workforce development program. Testimony is clear. They use the entire structure. In fact, they need an entire constructed structure, or their workforce development program doesn't have a purpose or an existence. Those materials have to be connected together. They have to be assembled, and they have to be taken apart. And
so let me ask that follow-up question to that then. So you say what was returned unquestionably had value in my shirts example.
Correct.
Probably not correct, but okay. You say what's different here is what's returned had no value. And so let's take the foundation as an example. You concede, I think everybody understood the foundation wasn't going. And your claim here is that it had no value. But your appraisal B, actually assigns value to the foundation, right? It takes a 17% reduction on the $27,000 that are spent on the foundation, and that's included in the value that the Manns deducted, right? Because the foundation, which everybody knows is not going anywhere, is part of the appraisal. So on the one hand, you say what was returned was valueless, And on the other hand, your appraisal, in fact, says that the foundation was 83% of $27,000. So I'm having trouble putting those two together.
So what the problem with that analysis, Your Honor, is that the IRS here is looking beyond. We're talking about the appraisal now. We're not talking about whether the entire interest was donated via contract. And we're looking to, okay, well, what did Second Chance actually do with it? You know, is this a situation where Second Chance carried the entire thing away?
I'm not asking what Second Chances did with it at all. You said that they had an option. I'm using your words. They had an option to take away what they want, but they were not going to take away the frame, the foundation, the roof, or drywall. Those are just examples you gave.
And
so if everybody knew that, then either A, they didn't give away all their interests, or your claim that those are valueless. Like, it's got to be one of those two. And if they're valueless, your appraisal, when we look at J927, is claiming value in the very things that you are also claiming are valueless. So either they can't have value and have no value. That's the problem you've got, is you're claiming value for appraisal, but no value for transfer.
What I'm trying to say, Your Honor, is in December of 2011, when those items are donated to Second Chance, they unquestionably have value. Second Chance runs its deconstruction program. 7 months later, it's done. It has deconstructed the house. It has destroyed the components of the house, and there is no value to the man's in whatever rubble is left on a foundation or whatever, roof is left.
When they started, did the foundation have value or not have value?
I believe it did, Your Honor. I would have to look at appraisal deeds.
So on day zero, the foundation has value. When Second Chance leaves, does the foundation have value or no value?
There's no value returned to the man's, Your Honor. It doesn't work that way. The
foundation is the same. So how did it have value on day zero and no value on day 100?
Your Honor, it's no different than if you take those same 100 shirts, give them to Goodwill. Goodwill now has taken ownership of all 100 shirts. And Goodwill decides, you know what? I'm going to use 95 of these valuable, I'm going to say they're valuable vintage t-shirts here because you've got an appraisal. And despite the fact that these t-shirts are worth $5,000 collectively, I'm going to use 95 of them as rags here. And we're just going to clean our facility, and they end up being discarded. Well, of course, those.
But who has the burden, in your hypothetical, who has the burden to destroy, to discard those rags? Salvation Army, because they own them, right? That's the point. They own them, so they must destroy them.
If you talk about a burden of demolition, that burden runs from the man's retained ownership in the land, and they had the burden of demolition because Second Chance, they can cart all the property away. That wasn't part of the agreement between the parties. The agreement was Second Chance, here's your property. You can do your workforce development mission. If it takes 5 years, it takes 5 years. If there's stuff left over, we understand we're going to have to demolish it because we still own the land and we want to do something with that land.
Okay, you got some rebuttal.
Thank you, Your Honor.
Mr. Rennie, we'll hear from you.
Good morning, Your Honors. Douglas Rennie for the United States. Intuitively speaking, the man's argument in this case doesn't make a lot of sense. They're essentially asking this court to uphold a $300,000 deduction for the purported donation of a house without the land that it was sitting on that they then paid to have demolished only a few months later. They haven't identified any cases that have held this type of deduction. There are several cases, however, that have rejected similar type deductions. As their own appraiser noted on page 915 of the joint appendix, the closest analogy is probably the donation of houses donated to fire departments for the purpose of burning down. In those cases, the Seventh Circuit and the tax court have rejected the deductions. As the Seventh Circuit said in the Rolfs case, none of the value of a house as a house was actually given away. The other problem with appraisal B here is it was never contemplated that the charity was going to disassemble and resell the entirety of the house's component building materials. So as in the Rolfs and Patel cases, the deduction of a donation of a house without the underlying land doesn't work for two primary reasons, either of which are sufficient to sustain the district court's decision here. First, the contribution was a non-deductible partial interest in violation of the restriction under Section 170 of the Code. Second, the appraisal failed to accurately describe the property and the restrictions on the gift from the man's second chance. And it's important to note that when evaluating either of these issues, it's the taxpayer that bears the burden of showing that they were entitled to the deduction. So turning first to the partial interest issue. Section 170F3 states the taxpayer cannot deduct the donation of a partial interest in property. It further specifically explains that the right to use property is considered a partial interest for these purposes, and that can't be deducted. So that brings us to the severance issue. The only way to donate a house without the land that it's sitting on is for the house to be severed. And that has to happen either physically or constructively. Physical severance, that occurs more frequently with a fixture, as the example they identify in their brief on page 15 is a door or a toilet. That's something that can be removed physically from a house without much expense or difficulty and without destroying it. Here, the house was not physically separated from the land until the man's contractor demolished it. And the parties never really contemplated that the charity was actually going to pick it up in its entirety and move it away. So that brings us to their main argument here, which is the constructive severance doctrine. Under Maryland law, the only way to constructively sever a house from the land is to record the transfer in the land records. Generally speaking, improvements are real property. The owner of the land owns the improvements. Real property has to be transferred by recorded deed. Thus, a constructive severance of an improvement from the underlying land has to be recorded. And there's clear and recent authority from the Maryland appellate courts on this point. The cases we've cited extensively in the briefs that the district court relied on below, the Greater Baltimore Medical Center case and the Townsend cases from the appellate courts. And those courts were relying on or in interpreting Section 3-101 of Maryland Real Property Law, and explain that there's a distinction between contractual ownership between private parties.
I'm in. Can you go to the next argument? I understand this one. I have trouble understanding the next one.
Sure.
And so, do you mind going to that one? I just don't want you to run out of time on that one, which I find more interesting.
No problem, Your Honor. The qualified appraisal issue.
No. I mean. So I understand you to be making two arguments with respect to the transfer. One is the recording doesn't sever. The second is even if it's severed, what they gave wasn't the full interest in the severed property. In fact, they just gave a use or a limited portion of the severed property to second chance.
Right. And I think part of our main disagreement with the Manns here is how they interpret it. And I believe counsel stated that you essentially have to, the contract is the beginning and end of the analysis. And that's incorrect for the purpose of federal tax law. We look more generally at, as this court has explained, at the true nature of the transactions. The formalisms don't control. We don't just accept the labels that the parties put on it. And among others, this court explained that in the BB&T case that we cited in our brief.
Can I ask a hypothetical to you that's slightly different? Your colleague on the other side said that the Manns had no interest in the house. That was the premise of his argument. If that was really true, would that qualify them for a deduction? So imagine the scenario where instead of what happened here, the Manns gave second chance the house in total. So they had the house the benefits and the burdens of it, and they had a 12-month easement on the property for that house. But at the end of the 12 months, they no longer had an easement. So they could go in and take everything they wanted to out of the house, do whatever they wanted to with it. But they also had the burden, the ownership burden of destroying the house, removing it from the property at the end of the 12 months. In that scenario, would they have given all of their interest in the house such that they would be able to get a deduction? Now, how much that deduction's worth is a different question, but would that be a full transfer in your view?
I don't believe so, Your Honor. Just to clarify, are you saying that who would have the burden of destroying the house?
Second
at the end of
chance.
the
They would own every benefit and burden. So they owned every board in the place, but they had the obligation to deal with, positively or negatively, every board in the place, right? They didn't get to leave behind what they didn't want.
So you're essentially saying, just to clarify so I understand, if they had severed this in a property in a way that the courts recognized, they had the burden of paying the property taxes, they had the obligation to remove the structure, and their interest is in the structure alone, not in the underlying land, but they only have 12 months to do so.
Yeah, they got an easement on my land for 12 months, but they get the whole house, right? Imagine it's like this famous house and everybody like really wants it, right? So, okay, but they get the benefit and the burden of that house, right? They get all the trappings of ownership, not just the ability to take what they want and leave behind what they don't. Wouldn't that be a full transfer? And I get your recording issue and I get your other issues. I mean, on this particular issue, that would be a full transfer of the interest in the house.
Under the scenario you're discussing, Your Honor, it sounds like that might work under probably the undivided interest exception. If it was truly severed, it's kind of akin to taking, 2 acres out of a 5-acre lot and saying, here you go, that's yours to do with what you want. That might actually work.
Okay. Same thing if I did like a condo in a 9-condo building, I take one of the condos and I give it to you, but you get all the benefits and burdens that go with it, right? That's the example that y'all give.
Right.
My hypothetical would be akin to that.
Right.
All right, so tell me why this case is different from that. What's the argument that you're making for why the Manns didn't do that?
Because they have none of the benefits and burdens here. What they have essentially is the right to come onto the property at times that are essentially dictated by the Manns. One of the things that's noteworthy here is they came at one point to remove aspects from the outside of the house. They couldn't do that until there was a demolition permit in place, which it was the Manns' obligation to go get because they are the true owners of the property. So it's the Manns telling them what they can take, when they can take it. I think there's some indication in the record that Second Chance wanted to remove some of the landscaping. The Manns told them no, they couldn't do that. And so the Manns are essentially dictating to them what they can do, what they can't do. It's not a situation where they're giving full right, title, and interest to Second Chance to do with whatever they want here. And the Manns still have the obligation to knock this house down. It was clear all along what was going to happen with this property. The Manns were going to rebuild on it. They retained that, which was probably the most significant right, which might be an issue for the hypothetical, not the condo hypothetical, but another hypothetical where the first hypothetical we discussed, which the Patel case discussed that.
Let me ask you a purely legal question about constructive transfer. If I sell my house and in my sale price, I agreed to retain a chandelier, a large chandelier that's a fixture in the house. At that point, there's a constructive retention of the chandelier and a transfer of the house otherwise, right? That's all constructive because there's been no severance. It's a fixture.
Right.
Doesn't constructive transfer always anticipate at some point in the future that there'll be a severance? In other words, if you just agree to a transfer of real property, sever real property and transfer it, but it never happens, it's still real property. The constructive aspect is the contract to sever, and it seems to me at some point it anticipates a severance.
That seems
is that supported by the law?
I believe so, Your Honor. In most of these situations, particularly some of the cases that the Manns are relying on here, they did involve situations where you have one party selling a property to another and retaining rights to remove various fixtures on the property. And in some cases, the contracts are actually contingent on them being physically separated. And the disputes are essentially between the parties to the transfer as to who owns or who has the right to remove property or the fixtures from.
But it seems to me if we just have a contract, and let's say it's even a recorded contract, but it doesn't matter for my hypothetical, you have a contract which authorizes the severance of a fixture so as to become personalty. It seems to me there's constructive transfer and the real property becomes personalty, but it's contingent on that actually occurring, isn't it? At some point, 130 years down the road, the chandelier has never been removed. There's got to be some kind of waiver, and that remains a fixture. I mean, we have the rule against perpetuities and all these other things that come into real property issues. I notice that the Manns argue sort of abstractly that a contract to sever is in fact a severance and makes it personalty. And my only point is it's still a fixture until it's taken. It's constructively treated as personalty, but it anticipates at some reasonable point on the law that there's a severance.
I think that's a fair point, Your Honor. And the cases we have from Maryland didn't even go that far because there wasn't a recorded contract there. So they didn't reach the question that you are posing, which is essentially if something that would otherwise be considered a fixture is left on the property, despite a contract saying that it could be removed, it would generally still be considered part of the real property. I think that's a fair argument, Your Honor. I don't know, though, if there is a decision in Maryland specifically addressing that.
Can you explain to me my hypothetical I gave to your colleague? So if I write up a contract and record it or whatever it is that you want me to do, but I got a contract with Salvation Army to give them 100 shirts. I get appraisal to come in and say that each shirt is worth a certain amount of money. And I agree to transfer all of those to Salvation Army, but they got to come to my porch and pick them up. And I agree that whatever they don't pick up, that I will destroy. I'll bear the burden of throwing it away. They show up and they only take 5 of the shirts. I assume you agree that I can't take a deduction for the entire 100 shirts. I'm limited to the 5, but help me understand why that is.
I agree with that, Your Honor. And I think what the distinction is what you're giving to the Salvation Army in that instance is not essentially ownership of those 100 shirts. What you're giving them is the right to come sort through those shirts and take what they want, which is not the same thing as going over to, or the equivalent here would be is if the Manns brought a bunch of building materials over to Second Chance's warehouse. Here's a bunch of lumber that we're donating. Here's a chandelier.
Right.
So,
this is what your colleague, I thought very helpfully described what was going on here was an option to take away, right? And an option to take, we don't tend to think of options as being ownership, right? So your colleague described this as an option to take away whatever they wanted to, and which strikes me as exactly right. This is an option to take away, but whatever options were not exercised remained both the benefit and the burden of the man's.
Exactly, Your Honor. It's an option is not full ownership. It's a partial interest. So unless it is actually realized by looking at what was taken away, what crossed the threshold of the warehouse, which we don't know in this particular case because the record doesn't tell us, then you don't have ownership of those items. And the only thing we do know in the record is that I believe Second Chance had said they spent approximately $13,000 on the labor to conduct their salvaging. And they also stated in their 30B6 deposition that the value of what they recovered was supposedly less than what they spent. I believe that's 506 and 511.
Do you agree that all these arguments that you're making, had Second Chance, stripped out and sold, $100,000 worth of lumber, to make it simple, that $100,000 worth of lumber, that could be considered a charitable contribution by the man's to Second Chance, because it is personality that has been carried away, and they could choose to give what's carried away in total. They're giving 100% of the interest in what's being carried away.
Yes, Your Honor. That would be like the 5 shirts that they've actually taken away that have gone back to Salvation Army and are being sold in their store. So yes, but short of that, they don't have the full ownership interest. It's an option, it's a license, it's a right to come onto the property to do something that would otherwise be a trespass and take the property away.
Anything further?
In closing, I would just say, Your Honor, what the mans are essentially asking for here is a federal subsidy financed by the government and other taxpayers to defray the cost of constructing their new house. The law doesn't permit it. The district court properly rejected it, and we would ask that this court affirm.
Thank you. Mr. Gayfield?
Thank you, Your Honor. When Second Chance showed up, they took possession of the entire structure. The contract was executed December 1, 2011, and days later, the government's argument ignores the practical reality. Days later, Second Chance showed up and they owned the structure. Second Chance had options to do things because they had all rights attendant with ownership of that structure. If Second Chance doesn't own that structure, they can't use it as a living classroom, and they're not going to be able to perform their mission.
No, but they plainly could, right? I mean, I'm not saying that that's what here, like that statement seems to me is like totally wrong, right? Is that you can be granted a license to do anything, right? So they could have been, now maybe your argument is they didn't here, but you don't really contend that they could not have been granted a license to do anything they wanted to the house, right? This is the fire example, right? You can be given a license to use it in any way. You don't have to receive full ownership rights in order to use it as a living classroom, as you hypothesize. That doesn't seem right at all.
Well, first, I would distinguish those licensed cases because the issue there is you didn't have a signed writing that satisfied statute of frauds conveying all right, title, interest. You had a condition that attached to it. Patel, the document, and the fire chief testified to this, gave them 1 day to show up and burn the house, and that was all they were permitted to do. Second Chance's testimony is very different here, and I think, to the extent we're going to use the record to assume that there were restrictions or conditions on that, it is contrary to the document, and it's contrary to the testimony of the parties at interest here. And we do have to remember we're up here on summary judgment standard.
Right, but you agreed. I mean, I'm just using what you agreed to. Like, you agreed that the contract did not envision Second Chance taking the frame, foundation, roof, or drywall. Right? Everybody knew they were going to be left behind to be destroyed. Right? I mean, that's not an unusual read of the contract. That's your read of the contract.
I disagree, Your Honor. The contract limited Second Chance in no way whatsoever. All rights in that property were transferred to Second Chance. It became personalty at that time. And Second Chance owned it and was able to dispose it, use of it, however it wished. There was the point is the Manns had absolutely no right of recourse against Second Chance. If Second Chance picked it up and carried away, whether the Manns can't complain, well, I thought you were going to deconstruct it. They have no right to complain about it.
Actually, that's not.
Option?
I'm sorry.
So that's also true if it was an option, right? The Manns would have no recourse if they had an option to do anything they wanted to with the property, but the Manns retained the obligation for the unexercised options. Then they could do anything they wanted to. I mean, your distinction doesn't change if this is just an option. I mean, again, I think I appreciate it. I think your example of this being an option is a good one. But also the Manns would not have an ability to complain whatever they did if it was an option.
Well, the real test, once again, is what does Maryland contract and real property law say with respect to conveying all your right, title, and interest in property from party A to party B? What do you need to do to comply with those standards? And that's what the contract does. And that's more.
Yeah, but in this case, if you were correct, then Second Chance could retain the house as a training center in perpetuity. Yet there was a clear understanding. I mean, under the contract, they could still be there, and the Manns wouldn't be entitled to build. And the facts of the matter are that everybody entered it with the understanding that the Manns were going to construct a new house there. They had already retained a contractor that included the demolition obligation, and so they knew the house was going to be demolished and made ready so that the Manns could build a new house. But yet, if you're right about holding the Manns to the contract, that couldn't have been done because Second Chance could have kept that house in place for 50 years.
And that's what both parties testified to, Your Honor. Those facts
that's a litigation stance. I mean, the fact of the matter is they both understood that the Manns were building a new house. They both understood there was a contractor. They both understood there was a demolition permit that the contractor would get. And they both understood that Second Chance would not take down the final portion of the house.
Your Honor, once again, I think that's the distinction between what actually occurred and what contractual rights were transferred in the first instance. And I think there's a distinction between what you look at to satisfy 170 and then what you look at in order to satisfy the qualified appraisal issue. To answer a question that was put to my colleague earlier by you, Your Honor, there's no case that holds that later in Maryland, that later physical severance of a previously constructively severed and conveyed improvement must actually occur. The fact is, 130 years later, setting aside whatever other rules against perpetuities, I think the owner of the conveyed improvement still has an action for conversion, assuming that contract is still valid. There's no time limitation on it, and I think to read that in misconstrues Maryland.
I'm not suggesting a time limitation. I'm suggesting a condition. In other words, a constructive severance created by contract anticipates an actual severance. Now, for some reason, there is no severance. The house gets blown down by a hurricane or whatever else happens is not the issue. The issue is what constructive means. And I think constructive has to be an anticipation of an actual severance in order to be personal property, to convert real property to personal property.
And my response to that, Your Honor, would be that's not what Maryland law and constructive severance actually says. I do see my time is up. If there are any further questions, I'd be happy to answer them.
Thank you, Mr. Gayfield. At this point, we usually come down as a court, as a long-standing tradition, come down and shake your hands. In the circumstances, we can't do that, but we do it virtually here, and welcome you to the court, and thank you for your arguments. We'll take this case under advisement, and you'll hear from us. Court stands adjourned.
Thank you, Your Honors.
Will you please close court?
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.
All right. Thank you.
Judges, I will move you to the